Hello students and welcome to the lecture. So students, as you can see here that we are going to start a new topic which is known as the public interest litigation. Okay. Before starting with the topic, let me tell you one thing that all the three things that we have discussed so far, two of them we have completed and one we are required to be started. Okay. So the judicial review, thereafter the judicial activism, and thereafter the public interest litigation. Okay, which is in short known as the PIL. All of these things are interconnected to each other. Okay, and there is a manner in which they are interconnected. Like if we talk about the origination, then the judicial review is basically originated from the constitution. Thereafter, the judicial activism is basically the extended form of the judicial review that we had discussed in the previous lectures of judicial activism. And the PIL, which is known as the public interest litigation, is the born child from these two areas. Okay, so this is just a base before starting the actual lecture. Okay, and these are the topics that we have scheduled for the discussion under this particular topic of public interest litigation. Like we will start with the introduction part. We will see the meaning of PIL. We will see what are the features of PIL. We will see the scope of PIL. We will see the principles of PIL, and even we will discuss the guidelines for admitting the PIL. Okay, so that is what we are going to start. First, if we start with the introduction part. Okay, so the concept of public interest litigation, PIL in short, basically originated and developed in the USA in the 1960s. So here we have also got a point to be connected with the previous point that we had discussed in the previous lectures. Like basically the USA stands for the United States of America, is the main source from where we had brought the topics of judicial review, judicial activism, and the public interest litigation. Alright, but there is a one thing that if we compare the provisions of this in India with the provisions of the United States of America, then there is a relaxation, or you can say less rigidity in the things. Why? Because if we talk about the USA, then the USA having the severe form of judicial activism. Okay, like the courts are empowered to directly interfere in the matters of legislature and the matters of executives. Okay, it is an extreme form. But when we talk about India, then this is less rigid form. Why? Because in India, there is two groups. However, these two groups also existed in USA, but when we talk about India, then they are somewhat more moderate than them. The group one is the, you can say, pioneers of the judicial activism. Like they claim the judicial activism is necessary so that the protection of rights of the people and even the welfare of the people could be ensured. Whereas there is another group which is the supporter of judicial restraint. It means that if we talk about the system of government, we had the three bodies. The first body stands out for the legislature, which is required to make the rules and regulations. The second body stands out for the executives, which are required to implement those rules and regulations. And the third is the judiciary, which is required to look after the procedures as per the constitution and check out the constitutional validity of the rules and regulations and the actions which have been taken to implement those rules and regulations. Okay. And the supporters of judicial restraint, they claim that every organ, whether it's a legislature, the executive, or the judiciary, having their well-defined roles and responsibilities. Okay, and if the judiciary unnecessarily interfere in the functioning of the legislature and the executive, then this will be the burden and the harmful situation for the democratic structure of the country. Okay, why? As we had discussed in the judicial activism, that there are limited resources in this country. Okay, there are so many challenges faced by the executives and the legislatures while formulating the policies and implementing them. All right, and there is a condition which I had told you also, that no one is the master of all. Okay, like the judge who is hearing the case, who is trying to exercising the judicial activism, there is possibility maybe the person is not so capable in different fields to understand that why the legislature has been passed off regarding that field and why the actions had been taken to implement the regulations in that particular field. Okay, so there are the conditions. Okay, but the judicial activism says that basically in India there is two things. The first is the fundamental rights, and second is the directive principles of state policy. And we know the fundamental rights are basically enforceable in courts and promised political democracy, which is sometimes also called as political freedom. All right. Whereas when we talk about the directive principles of state policy, the first thing we know about it is that they are non-enforceable in courts and they promised the social and economic democracy, which is also known as freedoms in these two respective fields. Okay, so that's the thing. So what we had seen, that the supporters of the judicial activism, they claim that fundamental rights are enforceable in the courts by the constitution itself, and they promise the political democracy or the political freedom. But the larger section of the society is covered by the social and economic democracy, which we also promise in the preamble of our constitution, which is the summary of the provisions we have provided in the constitution. All right, but this large segment is not enforceable in courts, and that's why it is totally depend upon the discretionary powers of the government. Like the government is free whether to make the rules, whether to implement the rules regarding the directive principle of state policy regarding the social and economic democracy rights of the people. Okay, so until or unless the courts not interfere in the matters of them, then they will not apply it. That is their point of view. Okay, thereafter, if we talk about the judicial review, then we know that it is only limited towards a checking of constitutional validity behind the legislatures and behind the executives. Now, what is the concept of public interest litigation? What is the concept of it? So before going to the definitions, the formal definitions, let me tell you the thing in a simple way. Like PIL stands out for the public interest litigation, is basically the tool exercised for judicial review and judicial activism. Okay, so it is the tool exercise for the judicial review and the judicial activism. Why it is so? Like you can say, until or unless the courts receive the complaint from the people, how they will react to it. Okay, so that's why the PIL is the tool. The PILs are usually files with the court, and then the courts could exercise the power of judicial review and the judicial activism on the topic on which the PIL was filed in the courts. Okay, so that's the thing. Again, we know that the judicial activism came into force, or you can say came into existence formally in 1949. But now the question is, who was the person first coined the term of judicial activism? For this, you have only 20 seconds to think an answer, then I will give you the answer and your time starts now. Just think about it. We had already discussed it for 2 times in the previous lectures. So I hope that you still recall the name easily. Only the 5 seconds are left. Already the time's up. So the person name was Sir Arthur Siglinger. Okay. He was the person who first coined the term judicial activism. And which country he belongs to? He belongs to the United States of America. Okay. So similarly, judicial activism, the public interest litigation was also originated and developed in the USA in 1960. In USA, it was designed to provide the legal representation to previously unrepresented groups and interests. Okay, it means that the groups and the interest on which the matters could not be brought to the courts by the victims. On this, basically you can say the case could be filed for the discussion by the person who was not to be the victim of that case. Okay. Thereafter, it was undertaken in the recognition of the facts that ordinary marketplace for legal services fails to provide such services to a significant segments of the population and to significant interest. Like we know, if we talk about the ground reality, we know that availing legal services in India, or not India in particular, is not so easy. Like when you go to the courts, you require the advocate or the lawyer to hire, and then the lawyer and advocate will represent your points of view, your case in the court, and then will help you to take the decision in your favor. Okay, so if we talk about it generally, so we try to get the best advocate and the lawyer so that the possibilities of our winning the cases must be higher. Okay, and you can say the more efficient lawyer or advocate you will try to hire, the more fees you are required to pay. Okay, so that's why it is generally said availing the legal services is not so easy. And the same thing was realized in 1960 in USA. Like in the USA, the public, or you can say the courts itself, basically recognize the fact that basically the ordinary marketplaces, which are for the legal services, they are fail to provide the such services, to provide the right to defend themselves, the right to you can say make their case here in the courts for the significant segments of the population and the significant interest. Why? Because these areas are not so capable to present themselves before the court. Okay, such groups and interests includes the poor people, the environmentalists, the consumers, the racial and ethnic minorities, and others, which are generally under pressure or unrepresented groups and interests in the society. Okay, so that is the basic foundation how the PIL was originated and why the PIL was developed in the USA in the 1960. What was the reason behind it, how the things would go on, and what were the things. After this, if we talk about our country in India, okay, So basically, there is a question. Before going to this, I'm going to ask you one simple question, which I had also asked you in the previous lecture. Like, who were the pioneers of judicial activism in context of India? In context of India. Pioneers of judicial activism in context of India, who were they? For this, you have 30 seconds to think an answer, then I will give you the answer. And your time starts now. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13th, 14th, 15th, 16th, 17th, 18th, 19th, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, and 30. The time's up. So basically, if we talk about it, then the names were Justice Bhagwati, Justice Iyer, Justice Reddy, and Justice Desai. Okay, so these were the people, and these were basically the pioneers of the PIL system in the Indian context. Okay, now let's talk about the people who brought the pioneer in India. Sorry, the PIL. So the PIL is a product of the judicial activism role of the Supreme Court. As I had told you in the starting, that it is basically the born child of judicial activism. Like we know, when it's a matter of, you can say, when it's a matter of judicial review. So we know that basically we had brought this from the American Constitution. Okay, so we could say that that was originally presented in our Constitution. Okay, and judicial review is basically the power of court to volunteer for reviewing and checking of constitutional validity of legislature actions as well as executive actions. Okay, it is a power of court to volunteer for reviewing and checking of constitutional validity of legislature actions as well as the executive actions. Okay, but when it's come to the judicial activism, the first thing which you are required to make clear in your mind is that judicial activism was not originally presented in our constitution. That's the first thing. Second thing is that the courts generally could not directly volunteer for the, you can say, playing the part of activist. It's a matter of legislature and executive. Generally, they required the case to be filed with them, and the case could be filed by the public interest litigation. PIL in short. That is what I had told you. Okay. So it is the product of the judicial activism role of the Supreme Court, and basically it was introduced in early 90s. Whereas when we talk about the judicial activism, it was introduced in 1970s. Okay. Justice V.R. Krishna Iyer and Justice P.M. Bhagwati were the pioneers of the concept of PIL, which we could say, if we talk about these ones who are the pioneers of judicial activism. So out of this, Justice Bhagwati and Justice Iyer, these were basically also the pioneers of public interest litigation, PIL. Okay, so keep this thing in your mind. The question may be asked, like the four names would be given, like we had just seen, and the question might be like this: out of these four, who were the two who were the pioneers of the judicial activism as well as the public interest litigation? So if you have revised the topics in the well enough manner, then only you will be able to recall, like P.N. Bhagwati and V.K. Krishna Iyer. Sorry, V.R. Krishna Iyer. Okay. PIL is also known as variously social action litigation, SAL, social interest litigation, SIL, class action litigation, CAL. Okay, like we could say, if we talk about the different names of PIL, the first basic name is, let's move forward. If we talk about the different names of PIL, so the first basic name is public interest litigation, known as PIL. The second name is social action litigation, SAL. The another name is social interest litigation, SIL, and the last name is was call action litigation, CAF. Okay, so these are the four names which we you can say anonymously pronounce for the PIL, but the most common name which you hear the most is the public interest litigation. Okay, so here we had drawn some important facts which we are required. The first is the origin and development place. So the answer for this is USA. The second thing we had is you can say the year in which it was basically originated? The answer is 1960s. Thereafter, if we talk about the reason, so reason was failing of legal services to reach large or significant masses or interest. Okay, and if we talk about the parent form, or you can say the parent of PIL, so the parent was judicial activism. All right, that's the thing. Hereafter, if we talk about the pioneers of public interest litigation, or PIL in short, in the Indian context, then who were they? They were Justice P. N. Bhagwati and the Justice V. R. Krishna Iyer. Okay, so these were the pioneers of the PIL in the Indian context. Okay, and these were amongst the ones who brought the concept of judicial activism in India. Okay, thereafter, if we talk about the year of origination in India, or you can say the year of introduction in India, then basically the year was early 1980s when it was introduced in India. Okay, so these are the important points and figures that we have trained from this introduction part. Okay, so for this lecture, this is enough. In the next lecture, we will continue from here. Till then, just revise the facts and figures that we have discussed in this lecture and be ready for the another lecture. With this note, let's end this lecture and thank you.